reaction now to the Constitutional Court judgment around the decision by the IEC to reopen the deadline for the submission of candidates lists, which is something the DA had complained about, saying that it was invalid. The Constitutional Court not agreeing. Lawson Naidoo, Executive Secretary of the Council for the Advancement of the South African Constitution, CASAC, joins me now. Lawson, I'm confused. The order looks like the IEC and the ANC were off the mark in as far as interpreting the Constitutional Court order of the 3rd of September. But in the end, the finding of the Constitutional Court says, well, in the ordinary exercise of its legislative powers, the IEC was well within its rights to amend the timetable in this way. Are you able to help me make head or tail of this particular order?
Good afternoon. Thank you. Look, I think the important thing is the actual decision of the court. And the court has basically said that the Electoral Commission has within its legislative mandate in terms of the Municipal Electoral Act, it has the authority to amend the timetable for elections once in terms of that act. The focus was initially on whether the order of the court that was handed down on the 3rd of September permitted the IEC to reopen candidate nomination process or not. And the court said, well, the order does not permit that because it cannot be interpreted in that way. It read the order and interpreted that order very narrowly to exclude this from being permitted by that order. But the IEC, in their response to the DA application, did make the case that they have the inherent power in terms of legislation to do exactly what they've done. And they premised that argument on the fact that the right to vote and the right to stand for election are inextricably linked. And they are indeed so linked in terms of Section 19 of the Constitution. And the simple argument of the Electoral Commission is that once you reopen the voters' roll and allow people who may not have been registered to register or people to amend the areas in which they are registered, that means that those people are now eligible to stand for election or indeed to nominate other people or to support the nominations of others. And that the link between the two is such that once you've reopened the voters' roll, you have to, of necessity, reopen the candidate nomination process, which is what they've done. The Municipal Electoral Act permits them to do so, and the court has said that in the exercise of that legislative power, it is open to the Electoral Commission to do this. So that's really the sum of the judgment today, and the fact that the matter wasn't argued and the court was satisfied that it could reach this conclusion purely on the papers, I think suggests that it wasn't that difficult a case to determine, even though the judgment is perhaps not as clear as we would like.
So a lot of technicalities then, in as far as the law is concerned, Lawson Naidoo, the interpretation of the order of the Concord from the 3rd of September being the one issue, the other issue being the ordinary legislative powers that the IEC enjoys in terms of the Municipal Elections Act, Section 11(2) thereof. But politically, how does this look for the IEC? Will it look like, you are now fully clothed in legal justification from the Concord, you are well within your rights, or will it continue to, endure a battering from the opposition, for example, to say, yes, the law may be saying you are correct, but it now looks politically suspect?
Well, we need to go back. After the Constitutional Court order on the 3rd of September, the IEC had a meeting of the National Party Liaison Committee, which is a structure that exists where the IEC consults with all of the parties represented in the National Assembly. And at that meeting, they advised the committee that they were going to conduct a voter registration weekend, which we've just seen over the last 2 days. And they also said that they were going to reopen the candidate nomination process as a sequence of that. And in that meeting, 10 of the 14 parties represented in that committee agreed with the IEC. There were 4 parties that didn't, amongst them the DA. So to say that the IEC has taken a biased view of this and is acted in a manner that seeks to benefit one political party is entirely unsubstantiated. And those that are making these allegations are treading a dangerous path in terms of undermining the integrity of our electoral management body. Now, the IEC is not a flawless body. It has made mistakes and will continue to make mistakes, but it has delivered free and fair elections to South Africans over many years. And when it exercises power, as it does now, in terms of its legislative mandate, it should be supported in doing so, whether or not or the impact of that plays out against particular political parties. It's really unfortunate that when political parties, who are the key contestants in any electoral process, seek to become referee and player in that same process, rather than leaving it up to the Electoral Commission to do its job properly.
So we are on standby for a briefing by the DA. Let me ask you then, Lawson, from your own sense of, reading the situation, what is the likelihood that the decision now could be challenged based on the rationality or otherwise of the IEC exercising this power, which is from the Municipal Elections Act?
Well, I think it would be highly unfortunate if this matter were to be pursued further through litigation. I think the onus now on political parties is to prepare for these elections, to cooperate with the Electoral Commission that is working on a very truncated timetable now, with little more than 6 weeks left before the elections, to ensure that all of the many logistical steps that still have to be overcome are indeed able to be met, and that we do indeed have elections on the 1st of November, and that those elections proceed on the basis that they will ultimately be free, fair, and above all else, be safe from a public health point of view. So we need the cooperation of all parties with the IEC to deliver the elections that the South African voters deserve.
Just from your sense of experience with these things, Lawson, which is far more, extensive than what experience I can claim to have you ever seen any judgment like this where it looks like, the one boxer is against the ropes and, on everything, really, your interpretation of what we meant by reasonably necessary is completely wrong. In fact, the word used is unsound, and there's a suggestion that you basing it on that understanding may actually be flawed, basing your decision on that. But there's a way out for you in that actually, on a technicality, you are not really against the ropes. You come back and it's a technical knockout. This to me is just extraordinary. I don't know. What's your sense of how extraordinary this is?
Well, I don't think it's that extraordinary. I don't think it can be, described as a technical knockout. As I say, it's a part of the legislative mandate that the IEC has in terms of the Municipal Electoral Act to adjust the time frames when the date of the election has been changed, which it has in these circumstances. Even though the court made a strange finding that the election date has not been changed because with the court having previously set aside the minister's gazetting of the date, that there was no election date. Now, these are semantics, and one would have preferred for the court to be very clear to say, yes, the judgment of the order of the 3rd of September did not expressly permit this to happen, but you had the power to do so anyway in terms of the legislation, and to leave it at that. I mean, I think the court has created elements of confusion around this issue, and has not provided the clarity that is really necessary, particularly in an emotive elective period where we need calm heads and we need political parties to behave responsibly, and we need to be able to hold the IEC to account where necessary, but to also support them, to enable them, as I said, to deliver elections that the people of South Africa demand.
Lastly, Lawson, to the extent that some political quarters will read this judgment through an eye that basically seeks to cast aspersions on the Constitutional Court itself, which we did see in the last few weeks, if not the justices of the ConCourt, but perhaps the ConCourt as a system, our judicial system as a whole. What would you say to that?
Well, I think the first thing to say is that the judgment today was a unanimous judgment. It may not have been the model of clarity that we would have liked to have seen, but it was a unanimous judgment from the court. So I think that is particularly important. Secondly, the court has come under severe criticism in recent times for the clarity of its judgments, for the manner in which it's conducted itself in the face of the cases that it's heard, delivering judgments, not when they were expected. On Saturday, we saw the delay in the delivery of a judgment. And the manner in which the court has conducted itself. These are all issues that I think are of legitimate concern. But let us not throw the baby out with the bathwater in these matters and respect the decisions of the court, whether we agree with them or not. This is the part of the constitutional framework that we have. The court is the ultimate arbiter. And ultimately, we need to look at mechanisms of strengthening the constitutional court, particularly in the process that we're leading up to now, where there are a number of vacancies on that court that need to be filled. And hopefully those, when the court is back up to full strength, which will hopefully be in the next few weeks, that the court can resume its role as the overall arbiter and accord the respect that it requires and deserves from the people of South Africa.